Hello friends, welcome to the Point. In today's session, let's discuss about center-state relations. So, Constitution of India, being a federal in structure, it divides all the powers like legislative, executive and financial between the center and the states. And there is no division of judicial power, as the Constitution has established an integrated judicial system to enforce both the central law as well as the state laws. The center and the states are supreme in their fields, but the maximum harmony and cooperation between them is essential for the effective operation of the federal system, and therefore our Constitution, it contains an elaborative provision to regulate various dimensions of relations between the center as well as the states. The center-state relations, it can be studied under three broad categories. They are legislative relations, administrative relations and financial relations. Let's discuss about these relations one by one. Let's have a look into the legislative relations. So, Articles 245 to 255 in Part 11 of the Constitution, it deals with legislative relations between the center and the states. And apart from this, there are some other articles also which deals with the same subject. And also, like any other federal constitution, the Indian Constitution, it also divides legislative powers between the center and the state with respect to both territory and the subjects of legislation. The Constitution provides for parliamentary legislations in the state field under 5 extraordinary situations, as well as the center's control over state legislation in certain cases. And there are 4 aspects in center-states legislative relations. They are territorial extent of central and state legislation, distribution of legislative subjects and parliamentary legislation in the state field, and the center's control over state legislation. So let's discuss about all these 4 aspects. Territorial extent of central and state legislation. So our Constitution, it defines territorial limits of legislative power which is vested in the center and the states. Like the Parliament, it can make laws for the whole or any part of the territory of India. And the territory of India, it includes the states, the union territories and any other area for the time being which is included in the territory of India. A state legislature, it can make laws for the whole or any part of the state. But remember, the laws that is made by the state legislature, they are not applicable outside the state, except when there is a sufficient nexus between the state and the object. And the Parliament, it can alone make extraterritorial legislation. That means the laws of the Parliament, they are also applicable to the Indian citizens and their property in any part of the world. Apart from these powers, our Constitution, it also places some restrictions on the plenary jurisdiction of our Parliament. So we can say that the laws of the Parliament, they are not applicable in certain areas. They are the President, he can make regulations for the peace, progress and good government of the 4 union territories. They are Andaman and Nicobar Islands, Lakshadweep, Dadar and Nagar Haveli and Daman and Diu. And at present, Ladakh is also included and therefore 5 union territories. Regulations, it has the same force and effect as an act of Parliament, so that it may also repeal or amend any act of the Parliament in relation with this union territories. The governor, one who is empowered to direct that an act of the Parliament does not apply to a scheduled area in the state, or it can be applied with specified modifications and exceptions. The governor of Assam can say likewise directs that an act of Parliament, it does not apply to tribal areas, that is autonomous district, in the state or it can be applied with specified modifications and exceptions. And the president, he enjoys the same power with respect to tribal areas, that is autonomous districts in Meghalaya, Tripura and Mizoram. Distribution of legislative subjects. The constitution, it provides for threefold distribution of legislative subjects between the center and the states. They are list 1, that is union list, list 2 state list, and list 3, that is concurrent list in the 7th schedule of our constitution. Our parliament, it has exclusive powers to make laws with respect to any of the matters that is listed in the union list, and this list at present has 100 subjects, and originally it contained 97 subjects like defense, banking, foreign affairs, currency, atomic energy and so on. The state legislature has in normal circumstance exclusive powers to make laws with respect to any of the matters that is enumerated in the state list, and this at present it has 61 subjects, and originally it contained 66 subjects like public order, police, public health and sanitation and so on. Both the parliament as well as the state legislature, it can make laws with respect to any of the matters that is enumerated or listed in the concurrent list. And this list at present it has 52 subjects, and originally it contained only 47 subjects like criminal law and procedure, civil procedure, marriage and divorce, social planning, economic planning, labor welfare, newspaper, books and printing press and so on. And our 42nd Amendment Act in the year 1976, it transferred 5 subjects to concurrent list from the state list, that is education, forest, weight and measures, protection of wild animals and birds, and administration of justice. The power to make laws with respect to residuary subjects, that is the matters which are not enumerated in any of the list, that is in union list, state list as well as concurrent list, those are called residuary subjects, and it is vested in the parliament. And this residuary power of legislation, it includes the power to levy residuary taxes. Parliamentary legislation in the state field. So while distribution of legislative powers between the center and the states, it is to be maintained in normal times, but in abnormal times, that is a scheme of distribution, it is modified or suspended. So we can say that the constitution, it empowers the parliament to make laws on any matter that is enumerated in the state list under 5 extraordinary circumstances. They are when Rajya Sabha passes a resolution, during a national emergency, when states make request, or when to implement international agreements, and during President's rule. So let's discuss all this in brief. When Rajya Sabha passes a resolution. So if Rajya Sabha declares that it is necessary in national interest that Parliament should make laws on matter in the state list, and then the Parliament becomes competent to make laws on that matter. And such a resolution, it must be supported by 2/3 of the members present and voting. The resolution remains in force for 1 year, and it can be renewed any number of times, but it should not exceed 1 year at a time. And the law ceases to have effect on expiration of 6 months after the resolution has been ceased in force. And such kind of provisions, it does not restrict the power of state legislature to make laws on the same matter. But while in the case of inconsistency between the state law and the parliamentary law will prevail. During a national emergency, the parliament acquires the power to legislate with respect to matters in the state list, while a proclamation of national emergency is in operation, and the laws become inoperative on the expiration of 6 months after the emergency has ceased to operate. And here also, the power of the state legislature to make the laws on the same matter is not restricted, but in case of inconsistency or repugnancy, between the state law and the parliamentary law, the parliamentary law will exist or it will prevail. When states make a request, when the legislatures of 2 or more states pass resolutions, it requests the parliament to enact laws on matter in the state list, and then the parliament, it can make laws for regulating that matter. And a law is enacted and it applies only to those states which has passed the resolutions, and any other states it may adopt it afterwards by passing a resolution to that same effect in its legislature. And such a law, it can be amended or it can also be repealed only by the parliament and not by state legislatures. And the effect of passing a resolution under the above provisions is that the parliament, it becomes entitled to legislative with respect to the matters for which it has no power to make a law. So also the state legislature, it ceases to have a power to make law with respect to that matter. To implement international agreements, the parliament can make laws on any matter in the state list for implementing international treaties, agreements or conventions. And this provision, it enables the central government to fulfill its international obligations and commitments. So examples like United Nations Act 1947, Geneva Convention Act 1960, Anti-Hijacking Act 1982 and so on. So during President's rule, so when the President's rule is imposed in a state, at that time the Parliament becomes empowered to make laws with respect to any matter in the state list in relation to that state, and a law it is made by the Parliament, it continues to operate even after the President's rule. This is very important, please remember it. The law that is made during the President's rule by the Parliament, it continues to operate even after the President's rule. This means that the period for which such a law remains in force, it does not coterminous with the duration of President's rule. But such a law, it can be repealed or it can also be altered or reenacted by the state legislatures. Center's control over state legislation. So apart from Parliament's power to legislate directly on the state subject, under the exceptional situation, the Constitution, it empowers the center to exercise the control over the state legislative matters in certain ways, and they are: the governor, he can reserve certain types of bills that is passed by the state legislature for the coordination of the president. And the president, here he enjoys an absolute veto over them, that is over the state legislative subjects. Bills on certain matters which is enumerated in the state list, it can be introduced in the state legislature only with the previous sanction of the president. For example, the bills imposing restrictions on the freedom of trade and commerce. The president, he can direct the states to reserve money bills and other financial bills that is passed by the state legislature for his consideration during financial emergency. That is, the president, he can give instructions to the states to reserve money bills and other financial bills that is passed by the state legislature for president's consideration during financial emergency. So from all these three instances, it is clear that the Constitution, it has assigned a position of superiority to the center in legislative sphere. Administrative relations. Articles 256 to 263 in part 11 of the Constitution, it deals with administrative relations between center and the states, and there are also other articles that pertains to the same administrative relations. So distribution of executive powers. The executive powers, it has been divided between center and the states. So this power has been distributed except in few cases, and thus the executive power of the center, it extends to the whole of India. That is, to the matters on which the Parliament, it has exclusive power of legislation. That is, the subjects that is enumerated in the Union list, and to the exercise of rights, authority and jurisdictions that is conferred on it by any treaty or agreement. So similarly, the executive power of the state, it extends to its territory. on which the state legislature has exclusive power of legislation. So in respect to the matter of which both the Parliament and the state legislature have power of legislation, the executive power, it rests with the states except when a constitutional provisions or a parliamentary law that specifically confers it on the centre. And therefore a law on a concurrent subject, though it is enacted by the Parliament, it is to be executed by the states except when the Constitution or the Parliament has directed. Obligation of states and the centre. In the Constitution, it has placed two restrictions on executive power of the states in order to give an ample scope to the centre for exercising its executive power in an unrestricted manner. And therefore, the executive power of every state, it is to be exercised in such a way that should ensure compliance with the laws that is made by the Parliament and any existing laws which apply in the state, and it should not impede or prejudice the exercise of executive powers of the centre in the states. So in both the cases, the executive power of the centre, it extends to giving of such directions to the state as it is necessary for that purpose. And the sanction behind this direction of the centre, it is coercive in nature, and therefore Article 365 says that where any states it has failed to comply with any directions given by the centre, it will be lawful for the President to hold that situation that has arisen where the state cannot be carried on accordance with those provisions of the Constitution. It means such a situation, the President's rule can be imposed in the state under Article 356 of the Indian Constitution. Centre's direction to the states. The centre, it is empowered to give directions to the states with regard to the exercise of their executive power in certain matters. They are the construction and maintenance of means of communication that is declared to be of national or military importance by the state, and the measures that should be taken for the protection of the railways within the state, and the provisions of adequate facilities for instruction in the mother tongue at the primary stage of education to children, those who belong to linguistic minority groups in that state, and the drawing up and execution of the specified schemes for welfare of the scheduled tribes in the state, and the coercive sanction behind the central directions under Article 365 is also applicable in these cases, that is President's rule. Mutual delegation of functions. So the distribution of the legislative power between the centre and state is said to be rigid, and consequently the centre, it cannot delegate its legislative powers to the states, and a single state cannot request the Parliament to make law on a state subject. The distribution of executive power, in general it follows the distribution of legislative powers. So the President, he may with the consent of the state government entrust to that government any of the executive functions of the centre. So conversely, the governor of a state, he may with the consent of the central government, he can entrust to the state government of any executive functions of that state. And this mutual delegation of the administrative functions, it may be conditional or unconditional. The Constitution, it also makes a provision for the entrustment of the executive functions of the centre to a state without the consent of that state. But in this case, the delegation is by the Parliament but not by the President, and thus a law, it is made by the Parliament on a subject of the Union list, it can confer powers and it can impose duties on a state, or it can authorize the conferring of powers and imposition of duties by the centre upon a state. So irrespective of the consent of the state consent. Cooperation between the centre and the states. The Constitution, it contains certain provisions to secure cooperation and coordination between centre and the states. For that, the Parliament can provide for the adjudication of any dispute or complaint with respect to the use, distribution and control of waters of any interstate rivers and river valley. And the President, he can establish an interstate council to investigate and discuss the subject of common interest between the centre and the states, and this comes under Article 263 of Indian Constitution. Full faith and credit should be given throughout the territory of India to the public acts, records and judicial proceedings of the centre and every state. And the Parliament, it can appoint an appropriate authority to carry out the purposes of the constitutional provisions that relates to the interstate freedom of trade, commerce and intercourse. But no such authority it has been appointed so far. All India services, so like any other federation, the centre and the states, it also has a separate public services called central services and state services. So in addition, there are all India services like IAS, IPS and IFS, and the members of these services, they occupy the top positions or the key post under both centre as well as the state, but they are recruited and trained by the centre. These services, they are controlled jointly by the centre and the states, and the ultimate control, it lies with the central government, while the immediate control, it vests with the state governments. So in 1947, the Indian Civil Service, it was replaced by IAS, and the IP, that is the Indian Police, it was replaced by IPS, that is Indian Police Service, and were recognized by the Constitution as All India Services. And in the year 1966, Indian Forest Service was created as a third All India Service, and Article 312 of the Constitution, it authorizes the Parliament to create new All India Service on the basis of Rajya Sabha resolution to that effect. Public Service Commission. In the field of Public Service Commission, the centre-state relations are the chairman and the member of the State Public Service Commission. Even though they are appointed by the governor of the state, they can be removed only by the president. The Parliament can establish a joint State Public Service Commission for 2 or more states on the request of state legislature concerned, and the chairman and the members of Joint State Public Service Commission, they are appointed by the president. The Union Public Service Commission, that is UPSC, it can serve the needs of a state on the request of the state governor and with the approval of the president. And the UPSC, it assists the state when it is requested by 2 or more states in framing and operating the schemes of the joint recruitment for any services for which the candidates possessing special qualifications are required. In the next session, let's discuss about the administrative relations between the centre and the state. Thank you.